Assalamualaikum to Madam Aisyah. Today we are presenting to you about coursework 2, alternative dispute resolution, about adjudication. Today we are going to discuss about what is ADR, what is adjudication, and we are going to discuss about case law between Bertam Development Sdn Bhd as plaintiff and RNC Cergas Teguh as the defendant or the claimant. My name is Muhammad Akin Zafarullah bin Rosli. Let's proceed to the introduction of this coursework. So what is dispute? Dispute is a conflict of claim or right whenever one party of the contract requests something that other party under the term of contract. So first of all, there are two methods to settle the dispute, which is formal and informal. So for formal method, usually we will go to litigation process, while the informal we go to adjudication, arbitration, negotiation, neutral evaluation, and lastly expert determination. Okay, so what is adjudication? Neutral people that are involved in this case will be called adjudicator. So adjudication is also referred to a law of National Act 746, Construction Industry Payment and Adjudication Act, aka SIPA, that more specific about payment dispute to resolve the contractor company cash flow. So the next one, adjudication process are temporary binding, and the adjudicator specialize in the construction industry, while the decision are temporary binding. So it will set aside unless by the high court or decided by the arbitrator or the judge. It also the fastest compared to arbitration or litigation that may take up to 7 years of hearing. Next, adjudication is also flexible in terms of place and time to let the adjudicator investigate the case, and also it will be confidential to public to protect the good name of the company in the future. So, however, the adjudicator can be costly, even if not costly as the arbitration or the litigation process. The adjudicator jurisdiction is less extensive compared to arbitrator. The arbitrator decision are legal and binding, while the judge decision is legal and binding, that enforceable, that will have the consequences if not obey the rule of court. So the last one, adjudication decision can be set aside if there are elements of fraud or bribery. When there is a denial of natural justice, when the adjudicator has not acted independently, or when he has acted out of his jurisdiction. For this name of case law, Bertam Development Sdn Bhd versus RNC Cergas Teguh Sdn Bhd. Bertam Development as the developer of the housing project in Langkawi as the plaintiff, and RNC Cergas Teguh will be a defendant or the claimant. He also as the main contractor for this project. Originating summon number is WA-34C-55-03 of 2017. Malayan Law Journal Unreported number 1571, dated 13 October 2017, and judged by Lee Swee Seng.
Thank you to Hakims. Next, I will explain about the identification of case. Summary of the case is the adjudicator had gone through on the cause and the effect of delay. His conclusion was finding of facts well within his jurisdiction, and a matter that should not be disturbed, as this was not an appeal on merit. According to PAM, that have been agreed by both parties, the plaintiff contend that the defendants could not refer to the uncertified amount of variance work claimed to the adjudication. The architect failed to certify the amount due under variation works, and because of that, they refused to make the payment to the defendants based on their own breach. Due to this intensive jurisdiction under Section 25 SIPA, The adjudicator has the authority to rule on the uncertified amount. A payment claim does not need existence or issuing a certificate of payment. After that, the plaintiff make a cross-claim to the eligibility of the extension of time. The court held that the adjudicator would have to take into consideration the connected issue application of EOT once the issue of a LAD claim is brought as a set of defense. Not in this case was the override of authority. Plaintiff motion was declined by the adjudicator, as stated, once a matter was within his jurisdiction, as this matter of LAD. In this instance, the defendant is eligible for claims against the plaintiff. Following that, the defendant was successfully in getting the adjudication judgments to be enforced. Next, I will explain about the fact of the case. First, the claimant in this proceeding under the Construction Industry Payment and Adjudication Act of 2012, CIPA, is a defendant is in this case. The contracts covered the building, infrastructure, work and civil, internal electrical, smart TV and telephone system installation, and M&E infrastructure work installation for the project, which involved the construction of 47 units of two-story homes on a plot of land in Langkawi. But only 33 houses were built, and the defendant was exempt from performing landscaping work. The architect interim certificate amount of 2,404,394 ringgit and 84 cents were not paid to the defendants as claimant, because the architect had failed to certify the amount due to VO. The CPC was issued on 23 October 2015, and the DLP will end on 22 October 2017, and then the plaintiff claimed that the variation works were performed without the architect approval. Lastly, a cross-counterclaim for 1,937,000 in liquidated and established damage (LAD), which were calculated from 6 January to October 27, representing a delay of 149 days at a rate of 13,000 per day. That's all for me. Thank you.
Next, we will proceed with the decision of the court. In his adjudication decision dated 19 February 2017, the adjudicator determined that the plaintiff is obligated to pay the defendant around 4 million ringgit, which is made up of the unpaid interim certificate and the amount for works not certified but duly completed. Other than that, the plaintiff is required to pay the defendant the amount of around 4 million ringgit, which is adjudication sum plus 7.65% annual interest based on Maybank base lending rate. Thirdly, the adjudicator reduced the LAD amount to 42 days, totaling 546,000 ringgit after the second EOT application was approved, which had previously been denied by the architect. Lastly, the adjudicator only approved around 2 million ringgit of the total claim.
Next is conclusion. This court shall address these issues in the discussion because adjudicator's action may have exceeded his or her authority as defined in Section 15D of the CIPA. Whether the adjudicator overstepped his authority when applying Section 36 CIPA default provision to the uncertified claims. Land counsel for the plaintiff asserted that the adjudicator had exceeded his authority regarding the uncertified claims for variation works when he disregarded Section 36(1) of the CIPA opening clause, which reads, unless otherwise agreed by the parties, and that the default provision in Section 36 of the CIPA could only be invoked when written payment terms are absent from a contract. Besides, it was emphasized that the parties agreed upon payment terms were clearly spelled out in the PAM written contract, which was broke up. It was argued that the adjudicator was powerless to ascertain the terms of payment because the PAM contract did not contain such terms. Therefore, the terms of payment were already included in the written agreement between the parties. As in the case before this court, the adjudicator could not have invoked Section 36(1) of CIPA. Then, the plaintiff argued that the defendant was bound by the PAM contract and that it was improper to allow the defendant to breach the certification of payment terms agreed upon and specified in the PAM written contract that the plaintiff had entered with the defendant. The plaintiff knowledgeable counsel argued that since the defendant had consulted the payment mechanism being decided in accordance with PAM contract, the defendant could not, as claimant in the adjudication, refer the uncertified amount to the adjudication. Next, expert legal counsel for the plaintiff had provided the following summary of the certification and payment provision found in clause 30.1 of PAM contract, which is the architect agreed to exercise the right to certify payment, and if the certificate of practical completion has been issued, the interim certification may only be given out when the architect can determine the amount. This indicates that it was contractually agreed that an interim certificate could only be provided by the architect once the architect had determined the sum due in accordance with the said clause of the PAM contract following the certificate of practical completion. Lastly, a separate written agreement is not needed between the parties to give the adjudicator authority for making decision in place of the architect because the issue of the validity of the claim for uncertified variation works is one that is raised in the payment claims and thus falls under the adjudicator purview. We have a reference to adjudication for a payment claim that includes the amount certified in the various interim certificates of payment as well as the amount in the uncertified variation works, precisely because the architect did not certify the work, and as a result, the plaintiff as employer did not receive payment.
The lesson that we get from the adjudication's case are, first of all, appealing against adjudication decision. A significant number of the court challenge were filed with the goal to appeal and examine the adjudication result. The High Court will not re-evaluate the adjudication decision, hence the court does not have appellate authority regarding that decision. Therefore, a new hearing or trial was never the best course of action. Besides, the court is not a mere complaint counter. Unhappy parties frequently view themselves as victims and give an obstacle in response. Even if a party disagrees with the result, the adjudicator is not biased because he has carefully reviewed all the evidence and arguments before making his conclusion. Other than that, adjudication includes all but a limitation to payment claims submitted to an adjudicator. In essence, all payment claims presented to the adjudicator must be assessed in accordance with Section 27. This covers all additional claims acknowledged as a contractual method such as variations. Next, lesson about the question of violation of national justice and excess of jurisdiction. If an adjudicator renders a judgment for a contract that doesn't exist, that adjudicator may be held to be acting outside of his authority. Lastly, adjudication success depends on the adjudicator's ruling being upheld. The adjudication resolution, however, can be overturned by the High Court if one of the parties disagrees with it, but only if there are elements of deception or corruption.